So good day everyone. Let us continue our discussion on obligations of partners. So to continue chapter 2, who shall manage the partnership? Under Article 1800, either one or some of all the partners designated as a managing partner, either in the Articles of Partnership or after the partnership contract, have already been constituted, and if there is no agreement as to the management, it is vested on all of the partners. So by 1800, you could readily see on what are the two modes when it comes to the appointment of manager. First one is through the Articles of Partnership, and the second one is an appointment made in an instrument other than the Articles of Partnership. So let's start with number 1, appointment as manager in the Articles of Partnership. So basically the power of the manager involves, and of course he may execute all acts of administration, notwithstanding of course opposition of other partners, unless he would act in bad faith. So basically the power to manage is irrevocable, not unless there would be just and lawful cause. So the revocation is only because of just and lawful causes, and it should be by the vote of the partners with controlling interests. So if we have to remove the man, if we have to remove him without cause or for unjust causes, it should be of unanimous decision, including the vote of that partner, to be removed. The reason for that is because this already represents a change in the will of the parties, and there has been a novation, so it requires basically a unanimity of decision. So let's now proceed on the extent of power of management of the partner being appointed as manager. So if he acts in good faith, he may do all acts of administration and not ownership. When I say administration, management of the property despite the opposition of his partners. And then second one, if he act in bad faith, he cannot, however, he is presumed to be acting in good faith. Moreover, he really is in bad faith, then the controlling interest should remove him, as mentioned a while ago. So appointment other than the Articles of Incorporation, so that is appointment of the manager made in an instrument other than the Articles of Articles of Partnership. Sorry for that. So basically in this appointment of the manager, his power may be revoked at any time with or without just cause. So the reason for that, it's because such appointment is a mere delegation of power which is revocable at any time. And removal should also be done by the controlling interests. So as long as he is the manager, he can perform all acts of administration. But if the others oppose, then he could be removed by the vote requirement. So take note of that. And let's now continue. Under 1801, it really presents us a situation when there are two or more managers. So under 1801, there are requisites so that that provision would apply. So number 1 is there are 2 or more managing partners, and then no specification of their respective duties, and at the same time there is no stipulation that one of them shall not act without the consent of all the others. So there is no stipulation requiring for unanimity. So in that case, it's stipulated that none of the managing partners shall act without the consent of the others. So it means to say unanimous. The concurrence of all shall be necessary for the validity of that act. So the absence or disability of any one of them cannot be alleged unless there is imminent danger or grave or irreparable injury to the partnership. That's under 1802. So the general rule is if unanimous consent is required by all from all of the managing partners, even if one of the managers is absent or incapacitated, it is still necessary. So it means to say it's inexcusable so that the act of the partners would be valid. The only exception is that when there is an imminent danger or grave irreparable injury to the partnership. So, however, under 1802, as what I have read, it is not applicable to third person. So, the stipulation in the Articles of Partnership that any of the two managing partners may contract and sign in the name of the partnership with the consent of the other, it creates only an obligation between those managing partners. So, asking the other's consent before he could contract for the partnership because it's the stipulation. So, as what I've mentioned, hindi po excuse yung absence or incapacity, not unless, or disability, not unless there is an imminent danger, grave injury that may cause if hindi po mangyayari yung isang decision making. So, for that obligation is not imposed on third person who contracts with the partnership. Neither it is necessary also for the third person to ascertain if the managing partner whom he transacts has previously obtained the consent of the other. So, a third person may and has the right to presume that the partner he is transacting with or he has whom he have a transaction in the ordinary and natural course of business ay meron siyang consent of his co-partner, for otherwise he would not enter into the contract. So that's the natural presumption of that third person. But it would be wise for a third person, he could inquire whether or not unanimity is required, and if so, if such unanimity is present. Again, it would be wise, therefore, if the third person could inquire whether or not unanimity is required, and if so, if such unanimity is present. So, just for his own protection, it has been held that a sale by a partner of partnership assets without the consent of the managers is not valid in certain cases if there is no unanimous consent from other managers and there is a stipulation that unanimity is required. So another case is a case decided by the Supreme Court in Smith, Bell and Co. versus Aznar. T was an industrial partner which was authorized to manage, operate, and direct the affairs, business, and activities of the partnership, and to make, sign, seal, execute, and deliver contracts upon the terms and conditions acceptable to him, but has duly approved in writing by the capitalist partner. So that is the provision that's a stipulation under his appointment. So the firm was engaged in the business of buying and selling of merchandise of all kinds. One day, T purchased on credit or on utang certain goods regularly purchased by the company. But without first getting the authority of the capitalist partner. So in that scenario would be the partnership be liable or be bound? So the answer to that is yes. It's because the transaction, even if it's on credit, was routinary. So it is in the ordinary or natural course of business. So under the stipulation, the authority to purchase carries with it the implied authority to purchase as well on credit. So given the fact na he's given the authority to purchase, it doesn't mean na purchase would be limited only to one certain transaction like cash basis only. There is an implied authority to purchase as well on credit. So the requirement of written authority refers only to formal and unusual contracts in writing. So as what you've seen a while ago in the stipulation. What are the rules now when the manner of management has not been agreed upon? So generally, each of the partner is an agent. So each of the partners can be considered as manager. So as a consequence of that, what would be the effect? So all partners can do all acts of administration. So if the acts of a partner are opposed by the others, then the majority per head is what I've mentioned a while ago shall prevail, right? So in case if there would be a tie, then the tie per head na counting, then the vote of the partners representing the controlling interest shall prevail. So yung percentage ng share in the ownership or contribution to the partnership. Here, that is the stipulations under 1803. Although each is an agent, still if he acts, the acts of one as opposed by the rest, the majority still prevail. And when a partner acts as agent, it is understood that he acts in behalf of the firm. So therefore, when he acts in his own name, he does not bind the partnership generally. So if he is acting on his own name, hindi po representation yun ng partnership. Let's proceed. So generally, a sale made by a partner of partnership property is not binding on the firm if not authorized. However, said transaction may be ratified as when the proceeds thereof are spent for the benefit of the firm. And on the other hand, paragraph 1 under 1803, or the authority to bind the firm, does not apply if somebody else have been given the authority to manage in the articles of organization or partnership or through some other means. Of course, with proof on this point that somebody else was authorized must be given. The general rule are all our agents, they are all managers and all our agents shall prevail. So take note kapag mayroong specific mention as to what task he has to perform, then it shall bind. And what about alterations? So for important alterations in immovable property, unanimous decision is required. That is under paragraph 2 of 1803. So take note of that. So when we say kasi immovable property, the interest of the partnership basically is affected. Alterations include like acts of dominion or ownership. So basically, possibility of conveyance, possibility of change of the major features of the property, and not the ordinary use to speak of yung magiging changes when we say alteration. So let's now, is it allowed that another person or an associate or a partner may associate another person with him in his share in the partnership? Is it allowed? So it is allowed under 1804. So under 1804, as what I've mentioned as well, this is mentioned also in our previous discussion with regard to sub-partnerships, yung consent po of other partners is not required in a contract of sub-partnership. Take note of that. So, all the partners basically can associate his share to a sub-partner. So, just take note that that sub-partner is not yet a partner to the partnership, right? So, if you get my point. Basically, not unless all of the partners would consent to that and having that partner be a partner as well. But basically, it's a modification and change of the um, contract of partnership. So, no one, as a rule, no one can become a partner in the partnership without the consent of all the other partners. So, consequence to that, an associate or a sub-partner shall not be admitted in the partnership without the consent of all other partners, based on the reasons na the partnership is based on mutual trust, and a change in the membership is a modification na of the contract of partnership. And let's proceed. Hope that is clear with you. How about in relation to partnership books? Under 1805, the partnership book should be kept in subject to any agreement between the partners at the principal place of business. Every partner should have the right to access and inspect and have a copy of that book. So, it should be done nga lang at a reasonable hour. So, by this provision, it's given really by law that the partners have every right to access, to inspect, to copy the partnership books for the purpose, of course, to enable them that they could obtain true and full information of all the things which affects the partnership, right? So, basically, it arises also from the right that they have the right to every property of the partnership. Diba, co-owner sila. So, partnership book is an example of a partnership property, and every partner is a co-owner of that specific property. What is the reasonable hour under the law in 1805? Under 1805, Supreme Court had ruled that ang reasonable hour na sinasabi po ay yun pong business days throughout the year, and not merely yung some arbitrary period of a few days chosen by the directors. So, yun po And another important point under 1806, the article presupposes a going partnership or continuing partnership, not one pending for dissolution, for here, the right depends on the court's decision or discretion, nor to one already dissolved. So, hindi rin po pwede yung dissolved na at saka yung pending dissolution. For here, although the books belong to all the partners, in the absence of a contrary agreement, still, no single partner is duty-bound to continue the place of business for the benefit of others. Neither din, hindi rin po pwede si purchaser of the firm's goodwill duty-bound to keep the books for the inspection of the former partner. So, that is the in relation to 1805. Let's proceed now to 1806. So again, what is the value of the partnership's books of accounts? As the value of partnership books of account is considered as evidence. So they constitute as an admission of facts stated therein, an admission that can be introduced as evidence against the keeper or maker thereof. So if there would be violations, you could always go back to the records. As and this is true even if the books are kept strictly in accordance with the provision of law. So the only way out is to prove that the entries had been placed therein as a result of fraud or mistake, which is of course must be proved. So under 1806, basically, the partners has a duty to render on demand true and full information of all the things affecting the partnership, right? So to any other partner or to any legal representatives of any of the said deceased partner or any other partner under legal disability. So any violation to what I've mentioned is already could be considered as concealment. So take note under 1806 of who are those that can demand for information. So the duty of partners to give information, the reason for that is there must be no concealment between partners in all matters affecting the partnership's interest. So this is required by good faith. Thus, this duty to give on demand true and full information. So it could be in instances as well na wala pong demand because honesty demands the giving of vital information and refraining from all kinds of concealment. So I've mentioned who are those who can demand for information. So when it comes to duty to account, so under 1807, every partner must account to the partnership for any benefit and hold as trustee for any profits derived by him without the consent of the other partners from any transaction that he have entered into with the formation, with conduct, liquidation of the partnership, or anything because of the use by such partner of the partnership property. So here, that partner has a duty to make an accounting. The reason for that, the partners' fiduciary relations, diba? They are governed, the very foundation is trust and confidence. So the fiduciary relations between the partners are relationships of trust and confidence which must not be abused or used for personal advantage. So these provision under 1806, it refers only to profits derived by a partner without the consent of the other partners. That partner has the duty to account for that. So the trust relations exist only during the life of the partnership and not before nor after. So fiduciary relations do not exist between the persons still negotiating for the formation of the partnership, and then the trust relations end with the death of the partnership unless the foundation for the breach of trusts place even during the existence of the partnership. So take note of that, and we have some illustrations. A partner with partnership funds and unknown to others purchase a house in his own name. Who owns the house? It's the partnership, because the buying partner should only be considered as a trustee under 1807. Another, a partner in real estate business without the knowledge of other partners. So without the knowledge, without the consent, it's a common word, and he has to account. Bought a parcel of land in his daughter's name and subsequently sold the same at a profit. Should the other partners share in the profits? Yes, it's because the transaction could be considered an affair of the partnership. Real estate ang business ng partnership. So, it should be declared for the partnership. Another, A, B, and C are partners. A, as a result of transaction connected with the conduct of partnership, has in his hands so that it may be traced a specific sum of money or other property. A becomes insolvent, so is the claim of the partnership against A a claim against him as an ordinary creditor, or is it a claim to the property or money in his hands? So the answer to that is that the words "and hold as a trustee for the partnership profits" indicate clearly that the partnership can claim as their own, hence specific property, any property or money that can be traced. So A should be liable. Ano?